Yes, Mr. Minister.
My Lord, in my respectful submission, my learned friend made a really very unpromising defence of the judgment in his responding speech. He relied on alleged unspoken findings of the judge and didn't seek to support her analysis in the crucial paragraphs 189 to 193, and the defence of 186 to 188 was flawed for the reasons which I will come to. There are three authorities I just want to respond to briefly. I'm not sure it's necessary to turn any of them up. Firstly, he referred to paragraph 70 of Kuwait and the reference to the value judgment in that. As I hope I made clear yesterday, Lord Nichols made clear in that same paragraph that proximate cause was just remoteness in another form, and my learned friend accepted yesterday that legal causation is also just remoteness. And so we say, at least we're all agreed on that. The next authority that my learned friend went to was Meadows, and he referred to paragraph 55 of Meadows, where Lord Hodge addressed the sixth question in the set approved by the majority in that case. And he went on in paragraph 56 to say that the sixth question includes remoteness, and that focuses on the foreseeability of the harm which eventuated. So again, we seem to be agreed, proximate cause is remoteness, and remoteness is answered by foreseeability.
I don't think that is agreed at all. I understand Mr. Cuddingham's submissions to be quite to the contrary, I have to say. I understood his submission to be that, yes, foreseeability was the counterpart of remoteness. He said legal causation went wider.
Obviously, there are other considerations, and those are some of the points that Lord Hodge picks up in the next paragraph. He says that the sixth step is a number of separate questions which need to be addressed, and which, like the duty nexus, question 5, can be described as legal filters, and he refers back to Lord Sumption in Hughes Holland.
Absolutely, that's Mr. Cuddingham's position.
Yes.
He relies upon question 6 and the legal filters.
Yes, but the only filter that he relies on is remoteness.
That's not right. He says that you have to show that there's a proximate cause.
But according to Lord Nichols in Kuwait, proximate cause is remoteness.
Well, that's your submission. I appreciate that, but I don't think it's common ground.
Right. Well, I'd understood my learned friend to accept that legal causation is the same as remoteness.
Well, I don't think that's correct myself, but I appreciate that is your submission.
One of the other filters that is referred to by Lord Hodge is novus actus, but my learned friend accepted that he doesn't rely on that, at least anymore. It was something he sought to run in closing, and it is reflected in paragraph 79.3 of the judgment. And because question 6 is a legal filter, just as question 5 is also a legal filter, it means in our submission it is still helpful to analyse the counterfactual to see if the damage does or does not still occur when the legal filter is applied. And here, of course, we say that the fact there would be no damage when the legal filter is applied shows that this is not just a but-for test, but a true legal cause. The infringements were the true legal cause of the damage. Finally, the final authority Michael Benjamin referred to, he referred you to Fairchild for the huntsman example. And he said, oh, well, that is the explanation for the or a distinction that's drawn in some of the cases. I'm afraid we just don't understand that. Of course, the hunter's example was given in Fairchild, but in Fairchild that was just an example of but-for causation, and they were relaxing, we agree, in that case they were relaxing but-for as a matter of policy. And the reason for that is clear from the example. There is only a single cause of the injury, the bullet, but in that case of the two huntsmen, you don't know from whose gun it emanated. And so there is a relaxation to say, well, we can't say that either single huntsman was the cause, but we're going to find you liable anyway because you were both negligent. that may be, but it's clear that the A dichotomy is also appropriate for the question of legal causation, as the authorities show, and there's no dispute between us that the judge's quote 82.2, her quote from Ultraframe, where Mr. Justice Kitchen said, "But for is not enough. It must also be, as a matter of common sense, a cause." That is the right approach to the law. So that's not in dispute. And we say that where, in particular, in cases where there may be multiple causes of an event, it's not necessary to identify a single cause as being the cause, and to the extent that the judge was attempting to do this, she fell into error. The big point sought to be relied on by my learned friend yesterday on the judge's reasoning was the alleged decision by the car makers, not by Johnson Matthey, and he sought to rely on the absence of evidence that the car makers relied on the infringing nature of the cerium oxide. Now, we have numerous points in response to that argument, any of which we say is fatal to the point my learned friend sought to make. The first point is that this was not an argument run below. It was neither pleaded nor raised in argument. And in fact, the pleadings were limited to what JM thought of the samples. I can show you that if your lordships like. It's in the core bundle.
Well, it's not the infringing nature of the cerium oxide that is the point. The point is that the car maker's decision is to accept a catalyst, and it's not in dispute that the catalyst contains other component. And so the argument is, where is the evidence that the properties, the technical properties of the cerium oxide affected the decision of the car maker as to which catalyst they would buy? That's the argument.
That's the argument, but that was an argument that had to be run. There had to be an argument saying that it mattered that the car makers didn't place weight on the characteristics of the cerium oxide, and that was neither pleaded nor was it run in argument.
But his case is that the burden is on you.
Well, I understand that point, but in fact, not only was it not pleaded or run in argument by Neo, but Neo themselves relied on the feedback from the car makers in their attempt to show that the non-infringing samples made a difference. So they were running a positive case that there was feedback from the car makers that mattered. And can I show you that? It's the easiest place to see it is in my learned friend's closing submissions. I've got a short extract just to hand out. So, as your lordships will already have understood, Neo were running a positive case at trial that they could have made non-infringing versions of cerium oxide, and that made a difference to the outcome of the case, which of course they lost on. But as part of that submission, if your lordships go to paragraph 25 of their closing, the 936 and 954 were the alleged non-infringing samples. And in 25, they say, there's no whisper of concern from JM about the performance of 936 or 954. No suggestion that any OEM had been disappointed, that is the car makers. On the contrary, to the extent that the material was used to make catalysts for shootouts, it's apparent that the non-infringing material won those shootouts. So they were relying on the material as being important for winning the shootouts. And then on the following page of the extract we've given in little 3, right at the bottom of the page, the penultimate sentence, again, this is on the non-infringing point, they say, both JM and, more importantly, JM's OEM customers were apparently satisfied with that material. So that it was part of Neo's case that it mattered to JM's customers the nature of the material, and so it cannot be said that we should have run a contrary case at trial. Third, my lords, even if this was a point that could have been taken at trial, in our submission it would have been an evidential burden for Neo to bear, not for Rhodia. Neo raised the issue of the non-infringing alternative. They pleaded that JM didn't care if it infringed or not. They failed on that argument, but that's what they pleaded. And if they'd wished to go further and say that the car makers didn't care whether it infringed or not, that's something, an evidential burden that they should have taken on in the light of the other issues which they were already addressing. Fourth...
Well, sorry, can you tell me what's the legal principle you're relying upon there? You'll say the burden of proof is on Neo. Fine, I understand that submission. But what's the legal principle? I mean, the normal allocation of burden of proof is the burden is upon he who asserts. And the burden, I think, of establishing legal causation, I don't understand you to dispute that's on you.
No.
So why do you say that there's a shift of the burden of proof as regards this issue?
Well, I'm addressing the evidential burden. I'm saying as they went so far on the evidence to try and address the issue that JM didn't care about the infringing nature of the goods, then if they wished to run an argument that car makers didn't either, that was an extension of that argument, and it would have been for them to run. It was their evidential burden, not ours.
But can you help me as to why? I mean, I'm struggling as to why you say they bore an evidential burden on that question.
If it was an issue, it would have been their evidential burden. That's what I'm saying. It wasn't an issue, my lord. It wasn't pleaded.
Well, I can understand.
Yeah.
I understand the submission. It wasn't an issue. Okay, yeah. But then you say, well, if it was an issue, the evidential burden was on them. But why?
Well, because
just give me a reason.
They took the burden to show that the characteristics of the material mattered to JM. And if they wish to rely on the fact that it mattered to the car makers, they should think that was an extension of that argument. That's what I'm saying. And more importantly, perhaps, in our submission, the judge did in fact find that it mattered, and it was part of her overall findings. And so the suggestion that it was somehow a break in the chain of causation just doesn't stand up. And the reason that she was able to find this is that there were numerous sources in the evidence supporting the notion that it did matter. I showed you Ms. Brown and Mr. O'Sullivan's statements yesterday, and there were references in those to the car makers. I also showed you the patent and Dr. Brophy's evidence at the liability trial about the importance of the invention. And the way we see this in the judgment is as follows. Firstly, we're in tab 4 of the core. Firstly, paragraph 33 of the judgment on page 33 of the bundle. My learned friend took you to this paragraph, but of course he missed out the crucial sentence, the last sentence, where the judge found to function efficiently in catalyst systems, however, the cerium oxide materials need to maintain a high surface area at the temperatures encountered in those systems. So she was clearly talking about the catalysts, not just the pure cerium oxide there. Next, in paragraph 55, she records an email sent by Mr. Williams of Neo to Zama, who are the suppliers of the raw material in China, and he's asking there for 50 kilograms of material, and he says this is for prototype samples for their customers. That's JM's customers. That's the car makers. And then he follows up in paragraph 56 with a further email to Zama saying, "This is very important sample. If this material works well, we get the business for Zama. Make sure material selected to send to JM is best we can make. Do not rush it." So clearly, he wanted the material that was going to JM to go to their customers for prototyping to be the best material possible. So it's absolutely apparent that Neo thought that the customers cared about the quality of the material, and that's why they were asking for it to be the best. You see that also reflected in the judge's recording in paragraph 70, where another email from Mr. Williams to Zama, and he's asking for a larger amount of material here, 200 kilograms. He says, "This material is used for customer fleet trials." So again, that's the car manufacturers. "The last step in the catalyst certification program in Europe. It will open the door to bulk production in 2014. And then last line, make sure the material we send is from the best lot." So again, Neo believed that it mattered to the customers, that is the car manufacturers of JM, that the material was the best quality. And this was all about opening the door to bulk production. And this the judge reflects in her findings in 162, where she records this in the last sentence in particular, where she says this was used for customer fleet trials, in which Mr. Williams described as being supplies that would open the door to bulk production of the product. And finally, in 148, the judge records in the second sentence of 148, "As I've explained above, the maintenance of a sufficiently high age surface area was a key concern expressed by JM throughout the development process of C100N. And we infer, and we say that the judge is entitled to infer from this, that it mattered for the performance of the catalyst. That's why JM cared, because they wanted to make sure that their catalysts were the best they could possibly make, because that's what the customers wanted. And that's how they would win the platform and obtain the later overseas sales. So, my lords, we say that there was ample material in the judgment to support the finding.
You said finding.
Yes.
The only finding is in 162, which is actually a rejection of a different argument. The sentence that starts, "It would be wholly artificial."
So I would respectfully suggest the finding, there is a finding of one in paragraph 33 as well, my lord. I accept.
Well, that's the very general point about the surface area.
Yes.
This is a finding that it mattered to the car makers, as I understood it.
I accept that in recording JM's, in recording the email, she doesn't make express findings on this point. She can't be criticised for that because she wasn't asked to make express findings on this point because it wasn't, as I say, a pleaded issue. But to the extent that it is now sought to be relied on, we would rely on these as being material which the judge accepted. And we say the inference from the fact that JM cared was that the customers care as well. And so, to try and pull this together, in our submission, the last sentence of paragraph 186, it is not about a finding that there's no link between the infringing nature of C100N and the damaging overseas sales. It's about a supposed intervening contingency between the infringements and approval by JM's customers of JM's catalyst formulation, but it simply doesn't address any issue of a link between C100N or the catalyst formulation and the damaging overseas sales themselves, and so in that case it can't assist my learned friend or the judge indeed in attempting to bolster the findings in paragraph 193. Next, my lords, there was a discussion about the precise role of the infringements in the narrative which took place. And of course, we've always accepted that the infringing acts are confined to the supply of infringing product to JM in the UK. But the question is what damage flowed from these acts. And we rely in paragraph 154, on the judge's finding that, we just turn to 154, the judge found there that JM was using Rhodia's HSA 20 product, which fell within the claims of the patent, as the benchmark to compare with Neo's product. So it's clear that JM were relying on the aspects of surface area in order to assess Neo's product. And the judge makes the finding there. And then in 175, she records with apparent approval Mr. Knoll's evidence that the customers, this is the second sentence in 175, other factors that customers might consider would be the relative prices and performance of the competing products. And the important point to take from this, my lords, is it's not just our case that the infringements led to the qualification of the product by JM and subsequently the car manufacturers, and therefore were a significant cause of the overseas supplies, and much more than an opportunity, as we said yesterday. But it's also the point that the infringements continued to influence the later supplies of material to Macedonia and South Africa. Now, my learned friend sought to attack this in two ways. Firstly, he referred to timing issues, but as to timing, it's clear that the infringing supplies continue to impact on the qualification process throughout 2014. And the judge records this in paragraph 71 of the judgment, where she records that the specification for the product with JM was not agreed until September 2014. And if you recall in our skeleton argument, page 3 of our skeleton argument, we set out all the supplies that continued to to JM in the UK throughout 2013, 2014 and beyond. And it's clear that these supplies were being used in order to continue the specification process and to agree the specification in September 2014. And then JM went forward, having agreed the specification in September 2014, and started to validate the overseas production facilities as Neo had expected in early 2015. So there's no time difference which explains any purported gap which the judge was relying on. And so the position, once the foreign factories had been qualified in 2015, was as follows. The car maker had qualified its catalyst for a particular platform and had got that catalyst through emissions regulations. So the car maker was committed to using that catalyst with that platform because of the regulations and also because each catalyst is unique. And the upshot of qualifying the platform is that there was an expectation that supplies would be required over a lengthy period of time following the initial qualification. The car maker then rings up Johnson Matthey and says, well, we're going to make 1,000 of these 1.6 litre engines this week. We'd like some more catalysts. And in response to that, Johnson Matthey have to provide the same material that they have qualified in the UK. There's no question of them being able to substitute that material. They have to provide the same material because of the emissions regulations. And in making the choice as to whether to order from Neo or on the judge's findings from Rhodia for delivery in Macedonia, JM were assured in the knowledge that the physical characteristics and the performance of the product were the same as that which they had tested in the UK, the infringing product, and the status of the C100N as being included in a catalyst product that the car manufacturers had approved was also known and settled. And JM only knew these things and only had the confidence and the assurance to continue ordering material from Neo because of the infringing acts which had taken place and the qualifications in the UK. And so we say there's not just a true legal cause that Neo could never have been offering the goods to Macedonia without the infringing acts in the UK, but the infringing acts in the UK continued to influence JM and Neo throughout the further orders, because it was the same product as the infringing product.
I think you've got the point. Yeah.
I'm sorry, Arnold. And so that's why we say that there's a distinction in this case from the Xena or Gerber scenarios, because of the fundamental link to the infringing articles. And this is something that the judge failed to take into account in her analysis. She may have mentioned that the materials were infringing in her discussion section, but she didn't consider the impact of the infringements in this way. Finally, my lords, there's the issue of intention. And of course, we accept that the judge referred in paragraph 185 to "and intended that," but our point is that there's no consideration of the consequences of the fact that the acts were intended. And the consequences of the fact that the acts were intended are that it indicates that the defendant, Neo, at least believed that its acts could bring about the results that we complain about. So it shows that at least one party thinks that its acts were capable of causing the overseas sales, and that has to be, in our submission, a relevant factor in the analysis of causation and remoteness. And that's why we say the judge was wrong not to find that the answer to the remoteness question was provided by the admission that she recorded and which I showed you yesterday, which itself was given by Neo in order to avoid having to give any disclosure on the topic of remoteness. And so in those circumstances, we say it's very difficult to understand how the judge could find that the damage was too remote to be able to be recovered. And the final point, just going back to the where the damage emanated from. The damage emanated not from JM's customers, it emanated from JM's purchases of Neo's product. That's what we always relied on. And JM's purchases were made from Neo in the UK, the First Defendant. That is where the damage...
Your lost sales are losses of sales to JM.
They are.
So
Yes.
to that extent, I don't understand there to be any dispute. But do you take issue with the proposition that you would sell zero to JM if JM had got no orders from car makers?
That must follow, but the fact is that the qualifications that took place as part of the infringements in the UK, which allowed the platforms to be qualified, then led to the expectation that there will be sales because of further or future orders from the car makers.
Sure.
For reasons I've given.
Yeah.
So, my lords, unless I can assist you any further, that's what I wish to say.
Very clear. Thank you very much, Mr. Mitchell. Right. The respondent's notice.
Yes, a lengthy respondent's notice.
Well, don't let's be downhearted. I think some points are more important than others.
Yes, we have, my learned junior and I have overnight sought to trim the note and keep things swift.
Yes.
So
All right.
If I'm failing with that obligation, be sure to let me know. So I was going to start with the disclosure application.
Well, I wonder if that's really going to be the most helpful way. There are points of principle which your respondent's notice raises, at least one of them an important point of principle.
That is right. The difficulty with doing it in another order is that I won't get any notice. If my disclosure application is successful, I won't get much notice of what the document says to take account of and take instructions on. But if my lords would rather I started with the big question, which is of course territorial scope of duty, then I'm happy to do that.
Yes. I think we have sufficient time if we need it to be fairly flexible about how we go about this. And I think, having obviously had the opportunity to discuss this with my lords earlier, we're generally of the view that we'd like to, while we're focusing on the response notice, go straight to the points of substance without forgetting the grounds for which you don't have permission.
Yes.
So shall we deal with those first if it doesn't fatally
No,
hamper you?
I'm very happy to do that. So let's start with the big one, which is there a territorial scope of duty that
So this is
applies
RN1.
in the UK? That is RN1, my lord, yes. We say that the duty on an infringer of a UK patent does not extend to loss suffered by the patentee in relation to competition on overseas markets.
We're going to get a transcript of this also, but are you thinking of tracking your skeleton argument on this to any extent so that we can have it in front of us as you
Yes, I
speak?
think that would be helpful.
Yes, I have it at page 280 of the core bundle, internal page 10 of your document.
Yes. So my submissions on this point are going to come in under four headings. First, I'm going to respond to a simple question raised by the judge and the appellants about whether the scope of duty principle is even applicable to damages for patent infringement. Then I will show you how our case accords with previous authority in this court and with good policy as expressed in the US Supreme Court. That's the dissenting judgment of Justice Gorsuch. Then I will deal with the judge's treatment of the point, and then I will pick up one or two of my learned friends' main points in answer. So as to legal foundation, we can take this very quickly. In the very first paragraph of my learned friend's skeleton argument, they express doubts as to whether the concept of scope of duty in the tort of negligence can be transposed into patent infringement. And as to that, and I don't think we need to go to the cases, first in Samco, page 123 of the bundle, at H, Lord Hoffman said in terms that the scope of duty principle was applicable to claims in contract, tort, and under statute. He went on to explain that for statutory duties, the scope of duty should be derived by deducing the purpose of the duty from the language and context of the statute. Second, in Q8 Airways, the concept was applied to the tort of conversion. And third, in BPE Hughes Holland, where Lord Sumption confirmed that it was expressed in Samco as a general principle of the law of damages. That's paragraph 47, bundle page 682, excuse me. So we say it definitely does apply, and then there are previous applications which are closely analogous, we say, to the principle that we rely on. And the first case in that regard is Patterson-Zakonis. We say that Patterson-Zakonis applied the scope of duty to a copyright claim. Now, that was a claim for copyright infringement against a printing company who had innocently printed to order some cartons and leaflets, which were very close copies of packaging that had been used by the claimants. And as a result, when the infringing printed products were put out into the market, they resulted in passing off and damage to the claimant's reputation and goodwill. And the claimant sought to recover those downstream losses from the defendant printers. Now, the act of printing of the materials in issue was an infringement of copyright, and it was a factual but-for cause of the damage to the claimant's goodwill. No printed packaging, no damage, no passing off. And it's the reasoning of Lord Justice Goff that we particularly rely upon. And if this is Authorities Bundle 1, tab 3, and we can pick it up on page 57 of the bundle. So page 56 of the bundle. Towards the middle of the page, Lord Justice Goff, just one sentence into the second paragraph. The general remedy for damages for infringement of copyright is legislated by section 17 of the Act, and is there described as being such relief by way of damages as available in any corresponding proceedings in respect of infringements of other proprietary rights. So he's saying that take the same approach to damages for copyright infringement as for other proprietary rights, such as patents. Then he quotes from Lord Wright in Sutherland and Caxton to the effect that damages for copyright infringement can be awarded in the sum of the depreciation caused by the infringement to the value of the copyright as a chosen action. And my learned friends say that this authority is based exclusively on that proposition. We say that's simply not right, as the following passages make clear. You see, Lord Justice Goff goes on to state that the proposition is consistent with the wrong being an infringement of a proprietary right, and then he explains that profits diverted from the rights holder to the infringer are recoverable under the law of copyright, and he relies on General Tyre and Firestone, which is the preeminent authority regarding damages for patent infringement. So we say the reasoning that follows is, at least according to Lord Justice Goff, applicable to patents too. He then says the availability of lost profits and even additional damages does not mean that damages of the type claimed in the present case are recoverable. Why not? Because he says, and I'm at the bottom of the page now, here the plaintiffs are in truth claiming not damages for the depreciation of their copyright, but damages for the passing off of other goods as their own on the basis that such passing off has been facilitated by the defendant's infringement of their copyright. The reference to depreciation of the copyright is not limiting, it's just shorthand there for damages for copyright infringement. And then he records a submission by Mr. Jacob QC, as he then was, that these losses are recoverable as parasitic damages. And he says, I know, however, of no principle that whenever one interest of a plaintiff has been wrongly damaged, consequential damage to another interest of the plaintiff is necessarily recoverable. In each case, it has to be considered whether, as a matter of policy, the latter damages should be recoverable in an action founded on the wrongful invasion of the plaintiff's first interest. Now, this was before Caperone, Dickman and Samco, but we say that scope of recoverable damages there is a clear equivalent to the scope of duty doctrine that was developed in those cases. So there is a policy question.
Why do you say that? Because on the face of it, what he's saying is there's two separate and distinct torts, and you get damages for the one tort, copyright infringement. It doesn't follow that you get damages for the second separate tort of passing off.
Yes, but so the situation is that the second tier of damages was factually caused by the copyright infringement, and what he's reasoning here is saying that before you go ahead and award the damages for copyright infringement, you have to ask yourself the question, are they really damages for copyright infringement? And what he's saying is that these aren't damages for copyright infringement, they're damages for the invasion of a different right, which is the passing off.
Right. So what's the analogue in our case?
The analogue in our case is that the damages that my learned friends seek are not properly damages for infringement of a UK patent, but damages for infringement of overseas patents. So although they are factually caused by the UK infringement, if you stand back and look at the overarching policy and you look at how the loss relates to the causes of action that might be an issue, just as Lord Justice Goff is saying, those are really, in substance, passing off damages, we say sales to the to the North Macedonian and South African markets are really damages for infringement of local patents there. We say that the existence of another cause of action is not...
So that's the second interest.
My lord, yes, that's the second interest. And indeed, there's another interest in our case which comes between the two, which is the Chinese patent. So you could go further and say, well, I don't limit it to South African patent and the Netherlands patent. I can see that those losses might also be properly associated with the scope of duty that applies to the infringer of a Chinese patent. But that is as far as it goes. But that's because, of course, all the manufacturing was in China. The second case we rely on is behind tab 10 of the First Authorities bundle, and this is USP and London General Holdings. This was also a case concerning damages for copyright infringement, and the distinction in issue was between loss caused by the reproduction of the wording of the document and loss caused by the reproduction of the idea stated within it. So the analogue would be, well, the wording is protected by copyright. The idea within it would have been protected by a breach of confidence, but there was no action for breach of confidence. If I could ask you to turn forward, please, to paragraph 26. Page 374 of the bundle. This is the judgment of Lord Justice Laws. So just to give you, it may help to give you a bit of the factual background. The document in issue was called a CAA, and it recorded the details of an extended warranty scheme, and it had been wrongly retained by the appellant defendants when they were given it by a client, and they subsequently used it and revised it, and they used it to pitch for some business against the originator of the document. And the originator of the document had to lower their prices to win the business, and they said, well, this has been caused by your copyright infringement. You held on to the document, you shouldn't have done, that was an act of infringement of copyright. As a result of that, we've lost £111,000 on this deal that we pitched for. And Lord Justice Laws says this: the issue requires the court to consider the very basis.
Well, do you want us to read paragraph 26?
I don't think I need you to read all of it. I'm just, I'm going to take you to the parts that I need. I'm just so the introduction. It requires the court to consider the very basis upon which damages for breach of copyright are awarded. So it's a fairly fundamental question. And then you'll see a reference there also to a depreciation of copyright as the shows in action, and then a reference to Patterson's Zaconis. And then he said the master, towards the bottom of 26, you'll see, of course, the master rightly relied upon Gerber, showing that the usual rules of causation and remoteness apply in this area. And then 27, Mr. Munson took a point on foreseeability. And then at 28, Mr. Munson took a point on the chain of causation being broken. At 29, the judge says that these are the wrong points. None of these arguments touches the real point, which is what is the basis upon which damages for breach of copyright are awarded? The question cannot be answered without consideration of the nature of the wrongdoing which breach of copyright represents. And then moving forward to paragraph 30, he says that the true point is not to be found in Mr. Munson's elaborate arguments about foreseeability and breaks in the chain of causation. It is that on the facts relating to Powerhouse, that was the third party whose business they pitched for, the respondents have suffered no damage arising from the unauthorised deployment of the actual text of the CAA, as opposed to the idea or ideas which it contains. So this was another case of a mismatch between the cause of action and damages. again you had a but-for cause, but when you stood back and looked at the actual damage that was suffered, it wasn't properly to be associated with the cause of action.
So that might be rationalised in terms of there being an absence of legal causation.
My lord, yes, and indeed, if you are against me on my bright line point about territoriality, then I say that Patterson Zakonis and USP are both examples of legal causation analyses wherein the existence of alternative causes of action with better connection to the damages in question are determinative. Now, before leaving USP, I do want to just point you to paragraph 31, which my learned friends seize on in their written argument, and they say that's what it's all about. Very much not. Paragraph 31, the judge is pointing out another reason why the claim fails, which is that the original document, the template CAA, wasn't fit for purpose, and they needed to do a lot of work for it to use it. So that is an obiter addition, but it's not the ratio. The ratio of the case is that the scope of duty did not extend to these type of damages.
No.
Well,
the ratio is that the claimed loss is not attributable to any breach of copyright.
You're
more
right, my lord.
straightforward.
You're right, my lord.
It's not obviously concerned with scope of duty. It's simply that, as Lord Justice Laws says in paragraph 34, the appeal must be allowed on the simple ground that the claimed loss is not attributable to any breach of copyright.
Yes, so
not because it was unforeseeable or otherwise too remote.
I ought to have distinguished between what the judge says in terms and my submission based upon it. But if I could just provide some further support for my submission, you'll see at 35, Lord Justice Laws says, in a sense, the true basis for the appeal succeeding was just around the corner from Mr. Monson's skeleton.
Yeah.
He cited from two opinions of Lord Hoffman, which should have pointed the way to the real point of the case. And there's an excerpt from Lord Hoffman in Q8 Airways about the importance of assessing causation in the context of the cause of action. And there follows then a quote from Samco, which is along similar lines, but of course is also talking about or applicable to scope of duty. So I am reasoning by analogy and saying there's a very short step between what's going on here, and indeed one could rationalise, and I invite you to do so, both these decisions by reference to the scope of duty that is applicable on an infringer of these torts. But the direct reasoning in the context of patents that is of most assistance on this point comes from the US case, Western GECO, and that's the case I'd like to take you to now. That's in the third authorities bundle. Just to give you the background, the patent in suit in Western GECO, it's tab 34. Patents in suit were for marine seismic surveys for discovering ocean floor hydrocarbons, and the patentee, Western GECO, manufactured their patented system, but they didn't sell it. Instead, they sold services which used the patented system to companies abroad. The defendant, Ion, manufactured components of the patented system in the United States and then sold those components to customers overseas for assembly overseas. And then Ion's customers sold services using the assembled system in competition with Western GECO. Now, the claim for infringement was based on a provision in the US patent statute under which it was an infringement to export components that are adapted for an invention which would, if combined within the US, infringe a US patent. Now, we don't have any equivalent to that under our statute, but there's a sort of a territorial angle to the cause of action itself there. But the question was whether Western GECO could recover the profits that it would have made selling its services overseas. And if I could take you please to page 1068, I'm going to start with the dissenting judgment, and then I will show you where the majority deal with the issue.
Seems a little counterintuitive to invite this court to follow a dissenting judgment.
What you will see is that the majority don't really deal with the issue at all,
So we have to take a subjective view of the Supreme Court of the United States.
No,
they don't really deal with it. So let's look at the dissenting.
They don't deal with it because they decided on a different basis, and a basis which has no applicability in UK law. I refer to this judgment because it has an excellent reasoning of the policy that is to be associated, we say, with patent infringement on an international basis. Now, obviously, my lords could say you can decide it's of no assistance to you, but I do say that it's a well-reasoned judgment concerning that policy, and that policy arises on the facts of this case. So, in the first paragraph on page 1068,
Well, again, we're going to have a proper look at this.
yes.
I think we need to spend a little bit more time on what the majority is saying. I'm starting at 1058.
Right. So, well, I mean, the majority deal with this issue in one paragraph. If you'd like me to start there, I'm happy to do so.
Well, the gist of it is in the first paragraph of the first opinion, so far as the majority is concerned, appreciating that it deals with US legislation.
Yes.
Right. Okay, so where do we go within the majority opinion?
So the majority, if you turn please to page 1066. The second paragraph there, two of our colleagues contend that the Patent Act does not permit damages award for lost foreign profits. Their position wrongly conflates legal injury with the damages arising from that injury. It's not the better reading of the Patent Act. And then they say that under section 284 of the Patents Act, damages are adequate to compensate when they place the patent owner in as good a position as he would have been in if the patent had not been infringed. So there are two propositions there. Firstly, the dissenting judgment fails to distinguish between damages and liability, and secondly, that it fails to put the wounded party back in the position they were in pre-tort. That second proposition is contrary to Supreme Court authority here, both in Samco and in Meadows and Kahn, that you cannot take cognizance of that principle when you are engaged with the question of whether whether damages are permissible or not, whether that's for legal causation or scope of duty, because of course that principle that you put the injured party back in the pre-tort position admits of only factual causation. Now, we accept that factual causation is established, so it cannot assist on that question. The only remaining point is that that Justice Coulson fails to distinguish between legal injury and damages, and that's a point that I will show you where he deals with, and then I was also planning to show you some, we say, compelling academic commentary that supports the dissenting opinion. So, would that be a convenient moment to move forward to the
Thank you.
The dissenting judgment?
Yes.
So, in the first paragraph on page 1068, Justice Gorsuch explains that he agrees with the outcome He agrees with the majority opinion on everything they say, that the award of overseas lost profits does not offend against the presumption against territorial application of statutes. So that is what the rest of the majority judgment is discussing. And that was the basis upon which the Federal Circuit had dismissed the claim. He then says, however, that they reached the right result for the wrong reason. And the wrong reason is what the reason he says is straightforward. A US patent provides a lawful monopoly over the manufacture, use and sale of an invention within this country only, but Western GECO seeks lost profits for its uses of its invention beyond our borders. Western GECO assumes it could have charged monopoly rents abroad, premised on a US patent that has no legal force there. Permitting damages of this sort would effectively allow US patent owners to use American courts to extend their monopolies to foreign markets. That in turn would invite other countries to use their own patent laws and courts to assert control over our economy. Nothing in the terms of the Patent Act supports that result, and much militates against it. In other words, we say that the lost profits for overseas uses were beyond the scope of duty for patent infringement. ION was not under a duty to protect Western GECO from competition in overseas markets where the US patent had no effect. He then turns to the language of the US Patent Act, which prohibits making, using or selling an invention within the US. So this is the first full paragraph on page 1069. And he points out that making, using or selling an invention outside the US does not infringe a US patent. He records that Section 284 allows the award of damages adequate to compensate for the infringement, and we say that's not materially different to our own statutory language, where Section 61(1) allows damages in respect of the infringement. And then he continues, because an infringement must occur within the United States, that means a plaintiff can recover damages for the making, using or selling of its inventions within the United States, but not for the making, using or selling of its invention elsewhere. And then picking it up at the top of page 1070, no doubt Western GECO thinks it's unfair that its invention was used to compete against it overseas, but that's simply not the kind of harm for which our patent laws provide compensation, because a US patent does not protect its owner from competition beyond our borders. And we say that reflects the reasoning we've looked at in Patterson's Zakonis in USP and in Samco and Kuwait Airways. You can recover damages for the breach of the right in issue, but not damages for the breach of another right. Losses on overseas markets are not the type of harm for which a UK patent provides protection.
Is this right? Are you arguing by analogy in relation to the scope of duty points? Because there's no patent case which effectively says you don't get damages for breach outside the UK.
Well, there isn't one that says you do, where it's part of the
this
ratio.
surely must have arisen.
I don't believe there is a judgment to contrary effect in relation to patents. My Lord Justice Arnold will pick me up, I've no doubt, if that's wrong. There is some obiter comment that the same principle, the Gerber principles, might apply.
The nearest case is HTC, which I take it you're going to come to.
Yes. If you, in HTC, there's just an obiter remark, and the scope of the territorial scope of duty doctrine is not considered. It wasn't advanced because it doesn't arise on the facts of that case. I can go to it in more detail if you want me to, but I don't think we'll get much out of it because there simply isn't any.
I think we have to look at it for completeness. I appreciate your submission is really help.
Yes, I took it out of my note last night, but yes, we can of course go there.
I just raise that point because speaking for myself, I find that the scope of duty analogy strained.
Yes.
It seems to me that we're really on a different point as to whether you can get damages for overseas infringements in these cases. That's a long way away from the doctor advising the mountaineer. And there's a lot of academic writing about SAMCO, but it seems to me it's terribly simple that you don't get losses that would have happened anyway. So the valuer doesn't have a duty to protect his client against a drop in the property market, for example. That's really all that those cases are saying, and Lord Justice Laws summarises that, in my view, wonderfully well in the authority we've just looked at. So at the moment, I'm speaking entirely for myself, just struggling with the analogy. I understand these cases and why they're said, well, that simply doesn't arise from the wrong. This is a slightly different point because you say this is, by analogy, the dissenting judgment, this is what we should follow. But that's not by reference to different breaches of duty, simply that this breach doesn't cover that loss.
So the way I would put it is that the scope of duty doctrine addresses the question of whether the kind of loss in issue is recoverable by reference to a particular cause of action. Is there something in the nature of the loss which dislocates it from the cause of action that's being asserted? And that is why it's a question that is asked at the outset before you talk about putting the claimant back in position.
The kind of loss here is recoverable. Loss of profit is recoverable. That part of it in the UK has been settled. It's the same breach.
It is the same breach.
It's the same breach. It's simply another element under the same head of loss.
Well, my lord, plainly, if you take that view, then you're against me on this point.
Well, I'm just trying to see where it goes, because at the moment that's the difficulty that I have. I understand. Is it the type of loss that is recoverable given the scope of the duty? I understand that, but here it is a type of loss of profit, because in the UK, or in relation to the loss of profit in the UK, that's been settled. So it's just whether there should be a cut-off in relation to loss of profits not in the UK. And I understand why that's an issue, and I think I understand why that's an issue. I just don't understand why the scope of duty point helps. So I don't think it necessarily follows that I would then be against you on this point. It's just, I'm not sure at the moment to align myself with Justice Gorsuch that I think the reasoning is necessarily right.
Right. So the distinction that Justice Gorsuch is drawing is not the distinction my lord draws. You say, well, it's all lost profits and therefore it's all the same kind of loss. But that's not what Justice Gorsuch is saying. He's saying,
because he says the Act says you can't have it for overseas infringement.
No, well, I don't think that's. I don't think he says you get it from the language.
In my view, the Act's terms prohibit the lost profits sought in this case.
Right.
First paragraph.
That's right, but the terms he relies on are the fact that you can only infringe a US patent within its within the borders of the US. That's where he gets that reasoning, and that applies equally to the UK.
Yes.
And that's why that leads into his conclusion that it's not the kind of harm for which our patent laws provide compensation. So his distinction between the distinction he draws is between lost profits in the US and lost profits outside the US, and the latter, he says, are not the kind of harm for which patent laws, US patent laws, provide compensation, because a US patent does not protect its owner from competition beyond our borders. And we say that reasoning applies. A UK patent does not protect its owner from competition beyond the UK.
But at all events, your submission is that this point has not been decided in any case in this jurisdiction.
Correct.
Or until...
Until the first instance judgment.
Yes, of course. Or until 2018 in the United States either.
That's...
Well, it doesn't really matter, but I mean, it just echoing something my lord said a moment ago, to an outsider in this area, that seems rather noteworthy.
It is
either as showing that your argument has force because nobody's tried it on before, or for some other reason.
The position in the United States was that there were some earlier federal court decisions which said these losses were not recoverable. And then when Western GECO went to the Supreme Court, they overturned the federal court decision on that point, but only by reference to the rather narrow locus question that we saw in the main, in the judgment of the majority, and you have the dissenting judgment of Justice Gorsuch. Subsequently, it is a matter of controversy whether Western GECO has dealt with the point or not. So there are academic writers who think that US losses will not be, ex-US losses will not be recoverable because the majority didn't actually decide the point. So the position in the US is that there has been, the question has come up on a number of occasions and it is not finally resolved yet. Could I then take you forward, please, to 1074? And this is where Justice Gorsuch expresses some concerns about proportionality, which are relevant also to another aspect of our case. But in particular, the proportionality if you don't limit the effect of your patent to its, well, in this case, to the US. So about 7 or 8 lines down, here, for example, supplying a single infringing product from the United States would make ION responsible for any foreseeable harm to its customers cause by using the product to compete against Western GECO worldwide, even though Western GECO's US patent doesn't protect it from such competition. It's some springboard too. The harm flowing from foreign uses in this case appears to outstrip wildly the harm inflicted by ION's domestic production. The jury awarded 93.4 million in lost profits from use in 10 foreign surveys, but only 12.5 million in royalties for 2,500 US-made products. So that's a ratio of 7.5 to 1, which the judge describes as some springboard. In the present case, the ratio between UK product and overseas product is very much greater than that. And you may recall it from paragraph 112 of the confidential trial judgment. I won't read it out because the number is confidential. But it's an enormous disproportion. And then Justice Gorsuch posits what he calls a dramatic example, which closely reflects the facts of our case. So this is halfway down. Even more dramatic examples are not hard to imagine. Suppose a company develops a prototype microchip in a US lab with the intention of manufacturing and selling the chip in a foreign country as part of a new smartphone. Suppose, too, that the chip infringes a US patent and the patent owner sells its own phone with its own chip overseas. Under the terms of the Patent Act, the developer commits an act of infringement by creating the prototype here, but the additional chips it makes and sells outside the United States do not qualify as infringement. Under Western GECO's approach, however, the patent owner could recover any profit it lost to that foreign competition, effectively giving the patent owner a monopoly over foreign markets through its US patent. That's a very odd role for a US patent to play in foreign markets, as foreign law alone, not United States law, is supposed to govern the manufacture, use and sale of patented inventions in foreign countries. Now, for prototype microchip, read development sample cerium oxide, and you have something not at all far from the facts of our case. He then expresses concern that the tables could be turned and foreign courts could start awarding damages, reflecting a right to control the market for the chip in this country, even though the foreign patent lacks any legal force here. So that's a sort of inverse comity. If we behave in a jurisdictionally imperialistic manner, other states will likely do the same. And finally, he complains that the majority have simply failed to grasp, failed to address the policy that he's grappled with. He says they deal with it in a few cursory sentences. No, he says, sorry, I can't see the highlight now.
Bottom of 1075.
Yes, thank you. They deal with it in a few cursory sentences, and that the outcome is that damages adequate to compensate for the infringement include damages for harm from non-infringing uses. And that's really the heart of our case on scope of duty. I mean, it also feeds into some of our other arguments, because we say you can dismiss the appellant's damages claim through at least 4 different routes: scope of duty, proximate cause, legitimate trade, or barrier to legitimate trade, or proportionality. But the factor common to all of them is that the appellants are in substance seeking an award of damages for non-infringement. Non-infringing sales in the Netherlands, North Macedonia and South Africa, and non-infringing manufacture in China. I don't know if my lords want to take a break for the shorthand writer or press on.
Are we at a good moment in your discourse?
I was then just going to take you to the article written by Professor Holbrook on this point.
How many articles are we going to?
Just the one.
And does that...
That concludes our consideration of American jurisprudence.
All right, well, shall we do that now while we've got...
So,
in mind?
my lord, this is... If you could turn forward to tab 37. And then forward in that document to page 1106. Perhaps I'll give you a rest from hearing my voice. Could my lords remind themselves of the sideline passages on 1106 and 1107?
Yes, by all means. Right, he agrees.
I'm very grateful. So the reasoning there is that the distinction between liability and damages can be seen as a distinction without a difference from the viewpoint of the defendant, and that by awarding damages on overseas activity, that has the effect of regulating activity in another country. So I had taken you. Oh, well, that's the good moment then to.
All right, we'll break.
Take a short break.
Thank you very much.
you put it in white?
So there's still someone's typing. It's not only a machine, it's the other person.
No, it's much.
Correcting. It's human.
And then there's a second.
So, yeah, so I'm saying that
Oh yeah, yeah, cool. Yeah, so it's just you just need this to be done.
yeah.
White. Someone printed it. Yeah, you put it back. Yeah, but I haven't got the rest. We cut it. Yeah. Yeah, so that's the big place. Yeah.
Not ready in time, we'll bring it up on the screen.
Yeah, exactly. It's marked highly confidential. I don't think it is anymore, but as a precaution.
Thoughts raised?
Yes.
My Lords, could you please take the third authorities bundle and turn back to Meadows and Khan, which is behind tab 31. I just wanted to make good the point I made a little bit earlier on, because it does come up time and again in my learned friend's response on the issues of principle that arise on my respondent's notice. They keep saying, put the claimant back, pre-harm position. And it's dealt with expressly on page 167 by Lords Hodge and Sales. So this is after they've gone through their 6 questions.
Sorry, give the page reference again.
Yes, 1029. 1029. Paragraph 58.
Thank you.
So they've run through their 6 questions and they say that this analysis they think is helpful in the product of this analysis assists in the determination of the extent of the claimant's entitlement to damages in accordance with the principle that the law in awarding damages seeks, so far as money can, to put the claimant in the position in which he or she would have been absent the defendant's negligence. That principle, vouchsafed by Livingston and Rhodes and Watson, Laidlaw, Hopcastles and Williamson, is not the correct starting point of the analysis, as Lord Hoffman stated in Samco. It is better to begin by considering the claimant's cause of action, and the scope of duty principle is a general principle of the law of damages. Requires the court in determining the extent of the defendant's liability in damages to distinguish between what, as a matter of fact, are consequences of a defendant's act or omission and what are legally relevant consequences of the defendant's breach of duty. So that is the second point relied on by the majority in Western GECO in answer to Justice Gorsuch. And as a matter of UK law, it can be no answer to the point. Now there's one consideration that Justice Gorsuch did not address, probably because he was dealing with the profoundly unusual situation where the invention in suit was being used not in any country at all, but outside the territorial waters of any country. But we say that an additional important factor is the manner in which a patent protection is available overseas. There is a well-established internationally cooperative system of patent filing. The Patent Cooperation Treaty was concluded in 1970 and extends to all the world's medium or large economies, save for Argentina. But even outside the Patent Cooperation Treaty, you can get patents in almost every country in the world. The only countries which do not provide any patent protection are East Timor, Suriname, Somalia, Eritrea, and the Maldives. Now, this appeal raises a question of international policy, and the objective context for that policy question includes the following 2 related factors. First, overseas patents are available to control overseas markets. And second, the patent system operates in the manner of a patchwork, with coterminous patents granted by local national offices. And we say those 2 factors combine into the following proposition. If a patentee wants to assert control in an overseas market, it should apply for and maintain a local patent. And UK patent policy should reflect that proposition. My Lords, I was then going to go on to scope of duty in the judgment, and I'll pick up HTC as part of that because the judge did refer to HTC.
Right, so we've got to point 3 of your heads.
My Lord, we have. So the learned judge dealt with this issue, her reasoning begins in paragraph 89, where she said she had some doubt whether the concept or scope of duty was applicable to patents, and I've addressed that already. And then we can move forward, I think, to paragraph 93, where she refers to Gerber and the fact that an analogous argument was robustly rejected by Lord Justice Staunton. But the territorial question did not arise in Gerber, so the policy concerns associated with territoriality were never considered. You may recall when we looked at it yesterday that Lord Justice Staunton recorded that he could see no policy grounds for restricting the patentee's right to recover for convoyed sales. And he cannot have had in mind the territorial issues that are at hand in this case because they weren't before him. So we say Gerber can't really assist in relation to these issues. And then moving forward to paragraph 97, the judge reasons that non-infringing overseas sales are simply a subset of the more general proposition regarding sales of non-infringing products. Well, yes and no. I mean, logically, that is correct. But because different policy considerations arise, if it is an issue of policy, we say those questions have to be considered. Next, the judge referred to the decision of Mr. Justice Burst in IPCOM, and she's quoted the material passage, and the question wasn't an issue in IPCOM, but there's just a comment at the end of that passage. Note that this principle, that's the Gerber convoyed goods principle, is capable of applying to acts overseas too, in the sense that the fact that the convoyed sale happened to take place outside the territory of the patent would be no answer as long as the act was in fact caused by an act of infringement of the UK patent. My lords, that was an obiter dictum in circumstances where Mr. Justice Burst, as he then was, had apparently received no submissions about territorial scope of duty, or indeed about legal causation, which may that may explain why the only limit he has in mind is factual causation in the very last line there. And of course, it's well established that it's not enough to have factual causation. But once again, my lords, unless you conclude that, contrary to Justice Gorsuch and Professor Holbrook, no distinct policy issues arise, we don't see how this case can really assist. And the same applies to the other cases cited by the judge. This argument simply wasn't run. In most of them, it would have been obiter in any event. That's Kieran Amgen, Smith and Nephew and Convatec. There is one case where it could have been run. That's the Scottish case of Bayer Crop Science and Charles River Laboratories. But again, it wasn't. And then the judge came to Western GECO, and this is paragraph 104, and she held that the ruling of the majority accorded with domestic authorities. So with respect, at no stage did the judge actually engage with the policy questions, and nor did any of the authorities she relied on, with the exception of the 2 points taken by the majority in Western GECO. And I've explained why one of those points is contrary to the Supreme Court authority here, and the other is inconsistent with the approach in UK law to scope of duty generally, and particularly as discussed by Lords Nichols and Hoffman in Q8, which is to say that you need to keep in mind the cause of action when considering whether damages are recoverable. So, my lord, that is the point as the judge dealt with it.
Yes.
and I was simply going to pick up a couple of the points in response by my learned friends. I'm not going to go through all of them, but the first one that I do need to deal with relates to a case called Experience Hendricks, in which a territorial damages limit was rejected at first instance in the context of copyright. And this is the first authorities bundle, tab 11. And the key passage starts on page 421 of the bundle.
I'm sorry, page?
Page 421, my lord.
421.
And the paragraph.
Right, what's the case about?
So the case was about the defendants had distributed the Sunday Times with a cover mount CD on it, which contained a recording of some old Jimi Hendrix contracts from concert from the Albert Hall. And they
none
didn't.
of us are going to ask, and who is Jimi Hendrix?
And they didn't have the rights to do that, so it was an infringing CD attached to the Sunday Times. Meantime, there was a plan to produce a film of those concerts and with some associated footage, and there was going to be a worldwide release of that film. And the claimants said were aghast when the cover mount was sent out free, because effectively the ground that they wanted to till was being salted with infringing copies of the songs that they wanted people to hear for the first time when they went to see the movie. So they pulled the worldwide release of the film, and they saw worldwide losses as a consequence of the infringement of the UK copyright. And you'll see at paragraph 140, Mr. Hobbs, for the defendant, submitted that if they can otherwise show that the defendant's infringing activity caused them loss, the claimants are limited to damages in respect of loss suffered within the territorial limits of the UK. And at paragraph 142, the judge rejects the argument. And the reason he rejects it is that he says that sort of limit would need to be found in the language of the statute, and it isn't. We have 3 points on Experience Hendricks.
Right, hold on,
Yes,
it's 142. Yes, so considered to be a basic point.
Yes. So we have 3 observations about this judgment. First, that there is no scope of duty analysis carried out here by the judge. And we say that's contrary to Samco and Kuwait Airways. I mean, the principle was somewhat less developed in 2010, but according to case law, it is not simply enough to look at the words of the statute. One needs to examine the reason why the cause of action exists and the underlying policy considerations. Second, we say that the scope of duty policy considerations for copyright infringement are different to those concerning patent infringement. I've already explained how patents are intended to control local markets, whereas copyright is intended to protect the skill and labour of authors, artists and performers. And
but they're both territorial rights.
they're both granted as territorial rights, but that doesn't mean that they are intended to do the same thing. A patent is an instrument of market monopoly, and a copyright is not. And one can see that different policy, we suggest, in the conditions for subsistence. So the vast majority of countries worldwide are signatories to the Berne Convention and to TRIPS, such that rights will be protected, copyrights will be protected without any formal requirements all over the world. On the other hand, patent protection is subject to a discrete decision in each country. So the policy about a patchwork of rights where a patentee elects where to obtain protection and pays for that protection, or where a third party establishes freedom to operate through a revocation action, that policy simply doesn't apply.
So how does this work out?
To copyright.
You will maybe have a rough idea. Take car industry and a standard component such as a catalytic converter. Approximately how many jurisdictions might one seek a patent in?
Be very conventional to seek it in hundreds of jurisdictions.
Right. So, well,
but
I'm
certainly
not sure
all
there
the
are
major-
hundreds of jurisdictions, but
So
let's suppose one sought it in dozens.
well,
When you say
so one can very easily get a patent for the whole of beyond the European Union, because a European patent, you can get that to cover Turkey and Switzerland, and so the continent of Europe can be covered very easily indeed with a single application.
right,
And then the PCT, the Patent Cooperation Treaty, enables you to pick and choose. You just tick the boxes in your application where you want the application to proceed. So
right. What I'm wanting to ask you is, if you were to do what you say that Rhodia ought to have done if it wanted this relief, namely to get other patents to cover the worldwide extent, is your argument then that they would have to go around suing in every such jurisdiction?
So, firstly, they did apply initially for
Well,
patents.
I'm not concerned with the facts of this case. I'm using them as an example.
Right. So formally, in order to recover relief on all overseas markets, they would need to sue successfully in those markets.
Right.
As
So
a matter of
let's suppose there were. I mean, I still don't have a clear idea. You said hundreds, and then
Yes.
we went back. But let's suppose there were 30 places that you'd need in order to get decent worldwide coverage. So your conclusion is that you have to go around suing on the same basis in every individual jurisdiction.
So, as a matter of practice, parties very rarely litigate in that way. So, for example, in Europe, oftentimes the decisions in Germany and the UK will be determinative of the position adopted by parties throughout Europe and sometimes more widely. So, formally, yes, if you want to police the market in Macedonia, you need to sue in Macedonia. But what would realistically have happened on the facts of our case, if there had been patents in all these jurisdictions, is that, there would have been a single action as there was, and I suspect there would have been a settlement.
There's proceedings, we know, in Germany.
There are proceedings in Germany as well.
Seems to have been
when-
at some point in the Netherlands as well.
Right. I think the Netherlands were just protective measures, but and there was a revocation action in China, on which my client succeeded. So it is not unusual to have multi-jurisdictional patent litigation. It is profoundly unusual to have it in 10s or 20 or 30 states, because there are dominant patent litigation states which sophisticated parties tend to take as resolving broader issues.
Thank you.
The final comment on Hendricks is simply, of course, that this is a first instance decision which does not bind this court. My lords can put that away, and there were just, so that I'm now on to the fourth head of my territorial scope of duty, and there was just one point I needed to pick up or flag from my learned friend's argument. So if you have the Rhodia respondent responding skeleton.
Yes.
If you could turn, please, to paragraph 23.
Page.
Page, I'm afraid I've only got the internal page,
All right.
which is page 6.
Yes.
315.
Thank you.
And the point they make here is that, well, they could have got an injunction at the outset which stopped any of Neo's activities in supplying JM, and none of the damage flowed. None of the damage now flowing would have occurred. If a properly granted injunction could have prevented the damage, why should not the same damage be compensated now? The answer is that that's just another example of putting the claimant back in the pre-tort position. The injunction they posit would maintain the pre-tort position, and that is because an injunction is an unrefined remedy that prevents all damage from occurring. It's a remedy that stops all factually caused loss, but it also stops all loss which is not legally caused. It stops damages that is damage that is unrecoverable as too remote or outside the scope of duty or not legally caused. So in effect, this is just another Watson-Laidlaw argument which is precluded by Meadows and Kahn. My lords, that's all I had to say on territorial scope of duty.
Anything else? No, that's helpful, thank you.
And perhaps I could move on to the points on the enforcement directive and TRIPS. So if you're following this in our skeleton argument, this is page 13. Now, our position on these issues has been repeatedly misunderstood, including by my learned friends in their skeleton, so let me state it clearly. The enforcement directive and TRIPS contain provisions which are intended to operate as a check on excessive relief for IP infringement. And the provisions work by requiring courts to ensure that when considering the relief to be granted on the facts of a particular case, that relief does not overstep certain boundaries. It is not our case that these provisions preclude the grant of any relief which might take effect outside the UK in all circumstances. So issues of proportionality and whether a damages award would constitute an impermissible trade barrier are matters of fact and degree. They're not absolute bars.
This arises only if you are unsuccessful on Respondent's Notice 1.
My lord, yes. If I'm successful on Respondent's Notice 1,
you don't need it.
Then that's a trump card.
Thank you.
So let me start by explaining why we say on the facts of this case, the appellant's damages award comprises a barrier to legitimate trade and is disproportionate. There's
Before we get into the detail, can you just help me on an issue of principle, which I'm not sure really matters because you've got two bases for the argument. Firstly, TRIPS, and secondly, the enforcement directive. But if we put the enforcement directive aside for one moment, how do you rely upon TRIPS? It's international law. So upon what basis do you say that that has effect in our domestic law?
I believe it was common ground at first instance and remains common ground now.
Well, I haven't seen it disputed.
Yes.
I'm sorry, this is a jurisdictional question.
Right.
And therefore the court needs to be satisfied.
Yes, of course. So the UK government is a signatory to TRIPS.
Sure. But that's no different to any other international treaty. So under our law, treaties signed by the government, ratified by the government, are not self-executing.
No, but they are. They remain relevant to the interpretation of UK law.
To be sure, but you're trying to rely upon Article 41 of TRIPS as having direct effect. I'm questioning how you do that.
Well, it may be that that is jurisdictionally incorrect to assert that it has direct effect, but it is in any event guidance for the court in considering what relief to grant in relation to a particular act of infringement. So if it's not of direct effect, it is still a treaty. The courts are still subject to a treaty obligation to exercise their powers in accordance with the terms of the treaty. Or to put it another way, the Section 61 of the Patents Act should be given effect in accordance with the terms of TRIPS. I think that's the way the authorities have dealt with TRIPS previously, as a matter of statutory, construing statutes to accord with it.
Well,
but I accept that's a slightly different question.
I'm not sure that's accurate. I mean, the way in which TRIPS has tended to be dealt with in domestic case law so far is that it's come in through EU law. Because, I mean, the basic proposition is that in some areas you have domestic law that has to be construed pursuant to the Mar-leasing principle consistently with EU legislation.
Yeah.
But then the Court of Justice has said that the EU legislation and domestic law of the national systems implementing that has to be construed consistently with TRIPS. So if you're within one of those areas, yes, then subject to the effect of Brexit, you can continue to rely upon that. But you haven't put before us any of the relevant jurisprudence in that regard.
No, I accept that I haven't. So perhaps we should concentrate on the enforcement directive, if that
it's a bit simpler.
Makes my lord more comfortable.
No, we're not here to do that. It's really a question of whether it's entirely up to you.
Yes.
If in reality this point turns on the directive, let's by all means get on and look at the directive. If TRIPS is just a detail alongside, then you're welcome either to maintain it or to leave it. But so we need to know one way or the other.
Right. So let me explain why it's there at all. Because at first instance, my learned friends, the appellants took a point that the enforcement directive was not applicable. And we had a slightly arid argument about that before the judge, which I think in the end, I think it may have been...
I don't understand any difficulty that you have with the enforcement directive. First of all, it was implemented within the UK and clearly recognised as part of the domestic legal order in many decisions prior to December 2020. Secondly, these proceedings were commenced in 2016.
Yes, and more importantly, all the acts in issue took place well before any Brexit.
Exactly.
So, which is why I think in the final event, my learned friend didn't press the point, and the judge didn't have to get into the debate. But certainly, I understand it to be common ground today that the enforcement directive is applicable in relation to these matters.
Right. In which case, we can concentrate on that, and we even worry about TRIPS.
Very good. So, getting back to the facts, we say there's a common justification for both conclusions, both the barriers and the disproportionality, and that is the disconnect between the patent in suit and the trade that is in issue. The patent in suit was granted as an instrument for the control of the UK market for the manufacture and distribution of cerium oxide, but the product that the remaining lost profits relate to was not manufactured here and was never distributed here. The only reason the damages claim can even be articulated is that a small quantity of development samples and initial commercial samples came into the UK. But that happened because it was convenient for Johnson Matthey. This was where they had their testing facilities for that sort of product. But so far as the United Kingdom is concerned, that was happenstance. It wasn't a significant market event. There is no commercial value accorded with that development activity itself. And if Johnson Matthey's testing base had been in the Netherlands or South Africa instead, where there was no corresponding patent, we would have willingly delivered to them there. It made no odds to us, because these were not commercially significant transactions. We didn't even charge for development samples. And that is why there's this dislocation, or if you will, a sort of a windfall element to the claim. It happens that there's a UK infringement in the early history of events that lead on to large-scale overseas commercial transactions, but that was simply a consequence of the manner in which the customer arranged its testing facilities. The activities that were inextricably associated with the UK patent were the sales onto the UK market. Those could only have taken place here, but there were very few of them, and that claim was easily settled. And we invite you to contrast that position with Neo's commercial sales to Johnson Matthey in South Africa, the Netherlands, and North Macedonia. Very significant quantities of product within Claim 1 were sold there. It was made into catalysts by JM. These are acts of distribution and manufacture which fall squarely within the policy of patent protection. Similarly, the manufacture of cerium oxide of RC100N in China. Every kilogram of our product was made there, and that would have been an infringement of a valid Chinese patent. But we revoked Anan Kasei's Chinese patent. Now the disconnect, again, one can see in the figures in paragraph 112 of the confidential judgment. Perhaps I will ask you just to remind yourself of that number now that it is squarely an issue. The last line in particular, that is the disproportionality that we rely on. As for trade barriers, can we consider, for example, the position of Johnson Matthey's agent in the Netherlands? Neo delivered product to them, and they treat it before supplying it to Johnson Matthey. The agent is domiciled in a member state of the EU and would rightly expect to be protected by the proper application of the enforcement directive. If they examined their distribution chain, they would establish that the product they are receiving is patent-free at source in China and on receipt in the Netherlands, and at every step in between. Invoices will have been raised in respect of product that has at every stage been non-infringing. And yet, if this claim is allowed, that whole trade becomes hopelessly non-viable. And Mr. Bolton, who was one of the accountancy experts, gave unchallenged evidence that the trade would be rendered profoundly loss-making if Neo had to pay the damages per kilogram that are claimed. Now, the rational response to such a decision would be for Neo to abandon the trade. It's going to be losing money hand over fist. So the trading activities of Johnson Matthey and their agent would be curtailed. And so we say that is a barrier to legitimate non-infringing trade. But those are the facts, and we can move on to see how they relate to the language of the enforcement directive, which is Authorities Bundle 3, tab 46. If you could turn forward to page 1269, you'll see Article 3, which provides a general obligation in relation to remedies for IP infringement. It says that the measures, procedures and remedies shall be effective, proportionate and dissuasive, and shall be applied in such a manner as to avoid the creation of barriers to legitimate trade. Now, we say legitimate in that context means non-infringing. Exactly the same wording is found in Article 41 of TRIPS, which is the origin for this language. both the Enforcement Directive and TRIPS are concerned with the protection that should be afforded to IP rights, and that means the relief that should be granted, either for alleged infringement, quia timid, or for proven acts of infringement. And if you look at Article 3, you'll see it comes in two parts, if you will. There's a part in favour of the rights holder. Remedies shall be effective and dissuasive. And then there's a check on that. Remedies shall also be proportionate, not barriers to legitimate trade, and provide safeguards against their abuse. So there's a balance between the one and the other. And that balance, we say, makes perfect sense if legitimate is construed as the opposite of infringing. That is to say, non-infringing. Now, there's only a narrow distinction between the parties on that. If my lords could take my learned friend's skeleton. Paragraph 33 of their responsive skeleton, internal page 8. And in particular over the page at the bottom of page 30, paragraph 33, they say that the distinction that's drawn here is between, on the one hand, trade which is infringing or caused by infringement, and on the other hand, everything else. So the only distinction between our approach and theirs is the inclusion of trade caused by infringement. And the reasoning they rely on is then set out in paragraph 34. But can I start with the proposition in general that trade caused by an infringement is not legitimate within the meaning of Article 3? We have three observations about that. First,
does any of this arise from the judgment?
No.
So why are we addressing it?
Oh, sorry. So I will show you how the judge dealt with it.
Well, I've seen how the judge dealt with it.
Yes.
The question of this question doesn't arise.
No, I thought
So whose appeal is it?
Sorry, so this is my respondent's notice.
Does it arise in your submissions to
Yes,
the judge?
I thought it would be helpful to
Just
explain
to
what-
follow my lord's point. You can have a respondent's notice to support the judge's conclusion
Yes.
for additional reasons, which one expects to find in the submissions that were made to her.
Yes.
So is that what we've got here?
Absolutely, Mark. Yes. And
So all you're saying to us is what you were saying to her, and you say she ought to have taken advantage
I'm
of.
saying that she could have relied on this as another reason why not to grant the damages that were being sought. Yes.
But she refused.
Indeed, my lord.
She said no. She rejected your submissions on this point.
Indeed.
She said it wasn't a limit. This is why I asked whose appeal is it? So you're not supporting her reasoning on this. You're challenging it.
No, this was a point I lost on.
Yeah.
So I'm raising it on my respondent's notice as an alternative basis on which she could have.
Yes, so it's a different basis for supporting the judge's order.
Indeed.
The judge's order was to dismiss Rhodia's claim for damages saved to the extent that it had been compromised.
My lord, yes.
So going back to the judgment then,
Yes.
the judge rejected this. You say what? That this was an argument that you made to her that she should have put in her judgment, and if she had done it would have led to a different result?
So she effectively...
I'm just a bit baffled. I know that everybody in this case is terribly keen to argue every single point all over again, and speaking for myself, I'm quite keen to avoid that.
Yes.
So where does this go?
So I do not accept the judge's reasons for rejecting this argument,
Right.
and so I am inviting this court.
Well, I don't, if I may say, I don't on this occasion share my lord's difficulty with this point, because let's suppose you lose on everything else. You need this.
I do.
If there's some argument that this is just a new brainwave that has come up on appeal, then we might be very reluctant to do this. But you've got permission to argue this, and it might, in certain circumstances where you were unsuccessful elsewhere, be necessary for your case.
My lord, yes.
Right. So let's press on.
So the reason I went to my learned friend's argument, because I thought it was helpful to deal with the construction debate, because it doesn't emerge from the judgment. And if that isn't helpful to my lords, then I apologise, and you can ask me to take things in a different order. But I've told you what my construction of legitimate is,
Yes.
and I'm showing you what the other argument is, because you don't get this from the judgment.
Yes.
The judgment deals with it on a much swifter.
Well, it's in the nature of respondents' notices sometimes that they don't find full reflection in the judgment.
Well, to be fair to the judge,
particularly if you've won the case.
well, exactly. She didn't need to deal with every point
Right.
that was unnecessary then.
Right. So we're now on page 317. Where do we go to next, or do we stay here?
So I just told you that the argument or the interpretation that my learned friends are putting forward, which is that legitimate, or rather, that the distinction being drawn in the article, in Article 3, is between, on one hand, trade which is infringing or caused by the infringement, on the other hand, non-infringing. And the only difference between us, you'll note, therefore, is that they say trade caused by the infringement counts effectively as infringing trade for the purposes of the article. And I had three observations about that. And the first is this, that it's so convenient and self-serving to be inherently unlikely. This is a very rare IP case concerned with the limits of legal causation, and it's not realistic to suppose that those drafting the enforcement directive happen to have the same issue in mind. Second, it is a profoundly uncertain interpretation. There is no unified approach to causation that could be attributed to parties to an international treaty. As a matter of UK law alone, the concept of causation is a profoundly complicated one, shot through with policy issues and moral judgments. Not the sort of thing one would expect to be implicit in an international instrument. And third, well, that is the third point, because causation is such a complex concept, one wouldn't expect it to be implicit. Now, if you turn then to the reasoning that supports my learned friend's argument, so this is paragraph 34, they say that if we were right about it, any remedy for non-infringing acts would be contrary to TRIPS and the Enforcement Directive. And as I've made clear at the outset, that's simply not correct. It all depends on the facts. A claim for a modest royalty might well be unobjectionable, but that very much was not this claim. Then they refer to multiple authorities where post-expiry judgments have been held not to offend these provisions. Post-expiry injunctions, have been held not to offend these provisions, and they refer to paragraph 116 of the judgment. And their submission is that there is authority that post-expiry patent injunctions can be compliant with TRIPS and the Enforcement Directive. Well, with the exception of Smith and Nephew and Convatec, we're not aware of any authority that even considers the point. And just to be clear, it is our position that it is arguable that springboard injunctions are non-compliant. Now, the issue about springboard injunction was addressed by Mr. Justice Burse, as he then was, in Smith and Nephew and Convatec. And that is JA2 tab 17. If you could turn please to page 587 of the bundle. Now, he rejected the application for post-expiry injunction on the facts, so this is all overturf. But in his reasoning, if you look forward to paragraph 121, he relies on the Court of Justice case of generics Smith, Klein and French, both there and in paragraph 130. Now, that was a case about Articles 30 and 36 of the EC Treaty. It was not concerned with relief for IP infringement under either TRIPS or the Enforcement Directive. And there was no decision about whether the injunction in issue was or was not a barrier to intra-community trade. So we say that still remains an issue for another case regarding post-expiry injunctions. And we also note that part of the judge's reasoning here at the end of paragraph 130 is that the Enforcement Directive does not in any event limit the remedies which are available. It provides a minimum standard. With respect, we say that that's not quite right. It does both. It provides a minimum standard and then a check on over-exuberant relief as well. My lords, that's the debate on the meaning of legitimate. There's then a smaller debate about what is meant by trade. And we say in this context, trade definitely covers the movement of physical product across national boundaries and the associated transactions, shipping, customs, treatment, purchase agreements. And as a result, we say the sale of a different consignment of product to a different customer is a different trade for these purposes. So there were different JM entities in South Africa and Macedonia when they bought product from that had been made in China. That was a different trade. What about convoyed goods? Well, if one considers the Gerber situation where you have a expensive and complicated fabric cutting machine and then subsequent sales of spare parts and servicing for that machine, if the former is infringement, it could certainly be arguable that the latter is not legitimate trade because it's so dependent on the parent infringing trade. But the Enforcement Directive was not enforced at the time of the Gerber decision, so it's a moot point and it doesn't arise on the facts of this case. Lastly, barrier. Well, in the context of damages, it's simply a question of fact and degree. As I've already said, a modest royalty might not give effect to a barrier, but a swingeing award which rendered the trade in issue non-viable would be. So that's barriers to legitimate trade, and then we come on to proportionality. As you will see from our skeleton, we say that the right approach to proportionality reflects the reasoning of Judge Wallach in the Western GECO case when it was before the Federal Circuit in 2016. And the case has bounced up and down repeatedly between the Federal Circuit and the District Court on a host of issues. And on one of those occasions, Judge Wallach had indicated his view that overseas damages were recoverable. And on this occasion, he restated that position in a dissenting judgment, and he gave us his view on the approach that should be taken to overseas damages. And in doing so, he provided some, we say, valuable learning on the approach to be taken to proportionality. So this is Authorities 3, tab 33. So just to set the scene, he thinks overseas damages are not ruled out as a matter of principle, And he's then conjuring with the question of, well, how much connection do you need between what happened overseas and what happened locally, the infringement?
Well, just to try and keep abreast with what you're telling us about. So he's in favour of the possibility of overseas damages. Yes. So he's wrong about that. And so where does he go to next?
So, but he accepts, he acknowledges that an infringement, a situation where a US infringement has no real connection to what went on overseas in terms of quantities is unsatisfactory. And if you have page 1051,
thank you,
right-hand column, third paragraph, the key issue left unaddressed in the now reinstated opinions analysis is when a patent holder successfully demonstrates both patent infringement under US law and foreign lost profits, what degree of connection must exist between the two before the foreign activity may be used to measure the plaintiff's damages? Put another way, left unanswered is the question of where we must draw the line as to when patented products or services made, used or sold abroad may be considered in calculating damages flowing from the infringement in the US. The issue is not one of infringement where foreign use generally does not count, but one of damages where it may. And then he reviews a number of the cases, and his reasoning starts on page 1054, right-hand column, second paragraph. He says, a unifying theme from these cases and others cited in my original dissent is that the appropriate measure of damages must bear some relation to the extent of the infringement in the United States. Thus, on the one hand, where the volume of non-infringing sales is independent of the extent of US infringement, those sales should not be used as a measure of damages flowing from the domestic infringement. For example, where a product is designed in the US by an infringing use of a patented method, and units of the product are then manufactured, sold and used abroad, the number of units produced abroad bears little or no relationship to the extent of the infringement in the US. This is because once a product is designed, an unlimited number of non-infringing units may be produced from that design. And then he says at the other extreme there may be a one-to-one relationship. So that would be where it was manufactured in the US and then exported. And we invite the court to embrace that reasoning and say that where the extent...
That's not reasoning about proportionality, though, is it?
Yes, it is. So this
proportionality, as we understand it,
so that
the EU jurisprudence, I couldn't see the word proportionality anywhere in the issue with which he was grappling.
No, it's not. He is not considering directly the question of the word proportionality.
That's what I meant. But you're saying that by analogy, this is what proportionality should mean. Delete United States and put in UK bear some relation to the extent of the infringement in the UK.
Yes, it's a little more than that, in that he's grappling with a very similar problem, which is when you have an infringement in one location and non-infringing activity in another location, which is said to yield damages as a matter of infringement in the US. What should the law look to as the relationship between the two before allowing a damages award? And so that's very much the same question that is before this court under a number of headings. And one of the headings is proportionality. And we say that this reasoning is in substance reasoning regarding proportionality. He's saying that we shouldn't allow these damages where the overseas activities are disproportionate. There's no relationship. And that's exactly the case here. We could have had 10 grams of cerium oxide coming into the UK and 1 million tons made in China. It wouldn't make any difference to my learned friend's submissions. And we say this is...
Check my bearings on this. This argument is posited on the fact that that you say that the overseas sales were non-infringing overseas sales.
It's common ground, my
Yes,
lord.
I said, but it's that the heft of the argument about the restraint of trade is to do with the fact that you're making non-infringing sales.
We're manufacturing non-infringing product and then selling it in a non-infringing manner.
Right. Could you just situate me in relation to your argument with an unrealistic example? But let's suppose that one had an infringing sale overseas. Where does that end up? In other words, that you, for example, let's suppose you knocked off a piece of intellectual property here and you just simply took it across to Calais where there was no patent,
Yes.
and sold it there. And let's suppose it was the sort of market where anybody was only going to be able to sell a very, very small number of specialist items. What is your situation as to liability in that instance?
So, can I try and answer that in a very slightly different way and see if it does answer my lord's question? Let's consider you had a manufacturing business in the United Kingdom, right? And so you make your product and you sell it both in the UK where there's a patent and in France where there isn't a patent, right? The sales in France aren't infringing, but there's a one-to-one relationship between the manufacture in the UK and the sales in France. Every product sold in France was made in the UK.
Right. Well,
And therefore, damages, lost profits for the patentee could extend to France without offending the proportionality
well, I
considerations.
mean, let's take a different situation where you've in England and subject to a UK patent, you've invented a nuclear fusion machine.
Yes.
And there aren't many of those around at the moment, and you don't sell any of them in England. But somebody in your lab simply steals the secret, and you go and make it in Calais,
Yes.
where there's no patent in existence. I mean, firstly, under the main argument in this case, ground of appeal 1, and under, secondly, your respondent's notice 2, where are you with that?
So, I mean, that's not a patent infringement. It's probably a misuse of confidential information.
Right, well,
But let me just tweak it.
Forget the details and tweak it so that it
Let me
works.
tweak it a little bit. So you make your fusion engine, and you apply for your patent in the UK, and then you publish it, which is what happens with patents. Anybody is free to do that, to use that invention where there isn't a patent. It is unobjectionable to take every line of the patent and copy it in France and make the machine yourself. There's nothing wrong with that. And it's absolutely fundamental. It reflects my argument about patchwork, that it is not objectionable to do these activities where the patentee has said, you go ahead. That's not where I want to patrol markets. If you want to control the market in France, you apply for a patent there.
Does that come to an argument that there are no circumstances whatever in which a trade or a manufacture in an unpatented jurisdiction could possibly be loss arising under a UK patent?
No, I don't think it does. So, leaving aside my territorial bright line argument, because as I've said, you could recover lost profits for sales in a non-patented location in circumstances where you manufactured the product in infringement of a patent. In that case, you've got the one-to-one relationship, and every product manufactured is an infringement. That's an act of infringement. And there is a direct relationship between that act of infringement and the sale of the same product overseas. So the causative relationship is far, far better. And what I'm really saying is that if my learned friends hadn't lost their patent in China, they would have been in a much better position to sue there in relation to the trade in Macedonia and South Africa.
Okay.
So, my lords, I was then going to go to the judgment, and the judge deals with this in fairly short order.
Paragraph 87.
I was going to take you to paragraph 115.
I beg your pardon, I'm sorry. I'm in the wrong place.
Page 49 of the bundle. So this is proportionality. And the judge said that there was no reason why a claim for lost overseas profits should be regarded as any more disproportionate than a claim for lost profits from the domestic sale of a non-patented convoyed good. And we agree, they're both subject to the requirement of proportionality. Then she said that if a claimant could show that a loss was foreseeable and sufficiently proximate, it wouldn't be disproportionate. Now, that is where we part company. We say that proportionality is not subsumed somehow within legal causation. I mean, it might be if you included Judge Wallach's approach as part of legal causation, but the judge didn't do that. So she appears to have decided that the requirement for damages to be proportionate cannot add anything to the requirements of legal causation, and we simply don't see how that can be right. They are distinct legal filters, and they need to be distinctly satisfied. And they needed to be satisfied by reference to the facts of the case and the particular relief in issue, and that was not an exercise that the learned judge carried out. And then she took much the same approach to barriers to legitimate trade in paragraph 116. She started by saying that if the argument worked for overseas profits, it should work on convoy profits. As to that, we think it applies a fortiori where there are issues of trade between countries, because the predictable movement of goods across international borders is a fundamental concern of the WTO, which is where this wording came from. But we agree it probably applies to convoyed goods too. The judge says the point wasn't taken in Kieran Amgen, Smith and Nephew or Bayer Crop Science, and we agree it wasn't. She records how in Smith and Nephew, Mr. Justice Birth indicated that a post-expiry injunction would not be contrary to the enforcement directive, and I've dealt with that already. And finally, she records that TRIPS did not preclude the award of overseas damages in Western GECO, but the point wasn't addressed in any of the judgments. So we say with respect that none of this reasoning engages with our arguments under this, our second respondent's notice point.
So let's just orientate ourselves in relation to this. We're assuming that the appeal on some combination of grounds 1, 2 and 3 is successful. We're assuming that RN1 fails. We would then be, RN2, this point, would then be the principal way of what? Extinguishing the damages or reducing them?
Well, I think the answer to that is that proportionality would extinguish them because there's simply no nexus. Barriers to legitimate trade, there's only one claim before the court, well, that's not quite right because I suppose you could separate out the royalty claim, but both of them are at a very high level, and we would say the question for the court is, have the appellants sought damages at such a level that it contravenes Article 3, and if so, the claim is not allowable.
So the proportionality and barrier to legitimate trade would extinguish
That's
claim.
that is my primary position.
I'm just finding out what was argued before the judge.
Yes.
That it would extinguish the claim.
But on the facts of the case and not extinguish any claim with it.
So there wasn't an argument for damages based on some sort of, I don't know, percentage of the UK losses, for example.
So important not to lose sight, my lord, of the fact that the UK losses have been fully compensated.
No, I understand that,
Yes,
but you were saying we were looking before, and one of your submissions was, well, one way of testing proportionality is by looking at what the UK sales were. So that if in principle this is recoverable, which is where we would be if we were looking at RN2, the question then becomes, does this extinguish it altogether, or does it leave something? And you're saying it extinguishes it altogether. And there wasn't an argument before the judge, as I understand it, that there was some alternative way of measuring loss so that it was proportional and in accordance with the directive.
My lord is correct. That is how it was. Yeah. It might have been open to my learned friend to say, well, I've got a backup. If my primary claim is objectionable on this basis, then I'll take a modest royalty of 1% or something. But that was never advanced.
Thank you.
I wonder if that's a convenient moment to break.
Where are we on RN2?
That is the end of RN2.
It's a very convenient moment. So how are we doing with 3 and 4 then? How long will they take you?
3 and 4 will take me 45 minutes.
And the permission?
The disclosure in 5 and 6 will be a little longer than that.
Right. But likely to finish your submissions on those matters today?
My lord, yes.
All right. 2 o'clock.